Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast. This edition, we're looking at domestic violence cases and, in particular, a reported case where the issue was making a DIFUS report, which is now called DCPP, could be considered domestic violence. And in the case of E.W versus W.M H, making the DCPP report itself is not automatic grounds for domestic violence. So in this rare reported law division case, the judges, or it's really just one judge, the question presented to the trial court was whether the immunity found to DCPP referrals found under the statutes also provides immunity under the Domestic Violence Act, under the I'll call it the child endangerment stuff, DCPP. That statute is 9:6-8.13. That gives immunities to the people who make reports. Then the question was, immunity from civil suit, but can there still be a prior, can it be considered harassment? The judge said, there was no prior reported cases. Looking at the statute, the trial court said it would be contrary to the legislative intent to confer immunity in the realm of domestic violence that would permit weaponization of DCPP referrals as a means of perpetrating domestic violence. This matter rose out of an application for a final restraining order under the Prevention of Domestic Violence Act. At the conclusion of trial, the only predicate act surviving was the act of calling DCPP to report allegations of abuse, and really in order to harass the victim. The trial court noted the legislature intended to protect children as the primary purpose in enacting the immunity statute regarding referrals. Let's see. Additionally, the statute 2C:25-18 expressly provides that children can suffer emotionally from the exposure to domestic violence and that children may also be a victim of domestic violence. Thus, the trial judge concluded that the application of the DCPP immunity statute to allegations of harassment falls as a matter of law under the doctrine of absurdity, even though the trial court found that the defendant committed the predicate act of harassment by making the reports. The trial judge ultimately found that the plaintiff failed to satisfy the second prong of Silver versus Silver and denied the application for the final restraining order. For more information on domestic violence cases and criminal cases, visit website N.J.S.A.com, and for representation, contact Kenneth Vercammen's office at 732-572-0500. Thank you.